know with the, how much time do I have left? 5 minutes? About 6 minutes. All right, my remaining time, I want to talk about and direct you to paragraph 33, and I believe this focuses on conversations at the Bedminster Club. The Bedminster Club is separate than the Mar-a-Lago Club in Florida, is that correct?
Yes.
Okay. And the Bedminster Club's in New Jersey? Is that your recollection from the indictment?
Yes.
Okay. In paragraph 36, you detail a meeting at the Bedminster Club in August or September of 2021. Can you describe what happened in this meeting and whether Mr. Trump shared classified information?
Well, I just want to start by saying I don't feel like I can say anything more than what's in the indictment here, unless you point me to anything otherwise. So I can read a portion if you want.
Please.
Well, in paragraph 34, references on July 21st of 2021, Trump gave an interview, and this was when he was no longer president, at Bedminster. 2 members of his staff were there, and the interview was audio recorded with his knowledge and consent. Before the interview, media had published reports that at the end of Trump's term as president, a senior military official purportedly feared that Trump might order an attack on country A, and the senior military official advised Trump against doing so. Paragraph 35 says, upon greeting the writer and publisher and his staff members, Trump stated, quote, "Look what I found. This was senior military officials' plan of attack. Read it and just show it's interesting." And then following that, there are additional statements that Donald Trump made regarding the document that he was showing and what other people in the room said.
Going to paragraph 36, did the individuals that Mr. Trump shared this information about the ongoing military operations with, did they have the security clearance or need to know about the classified information about that military operation?
In paragraph 36, it states that the PAC representative did not have a security clearance or any need to know classified information about the military operation.
Are you aware of whether the FBI conducted a similar search of Mr. Trump's residence at Bedminster?
Whether that happened or didn't happen, I'm just trying to be very cautious. I don't think I can answer that due to the injunction.
Do you think that the FBI was able to retrieve all the classified documents that President Trump improperly retained after he lost the 2020 election?
I'm struggling because I can't recall if that is in the final report, and because I'm not sure of whether it's in there, I don't think I should answer that question.
All right, we'll go off the record.
record, marking Exhibit 17. This is on the topic of the misordering of the documents, and there's a filing that I wouldn't ordinarily mark, but given the situation on the Florida case, we'll mark that because you, your office addresses what came to be a misordering of the documents. And so the question is, do you have any information about how the documents that were seized from Mar-a-Lago were misordered?
Let me start by saying I think there's also another filing on this that we did later as well. So between those two filings, what I can tell you is when a search warrant is executed at a location, there are documents in boxes. The search warrant can be executed in a manner where you just take out the documents that you're looking for, or you take the box with the documents that surround that. Both ways are proper. In this particular case, obviously the search warrant happened before I was special counsel, and the special master litigation occurred, or began certainly before I was special counsel. In that litigation, my recollection is that President Trump's attorneys took the position that the government should not have even taken all the documents in the boxes and just taken the classified documents, such that if things were done the way they proposed, there would not be other documents in the boxes. It would just be those. As I think we set forth in our filings, when this issue got raised initially in court, our attorney misstated that the documents were in fact in the exact order that they were found. I think you can see from the timing of these filings that once we realized that was incorrect, we corrected it with the court as quick as we could. And then at that point, when President Trump's attorneys were now alleging that this was an important issue, we looked into in more detail exactly why it was not possible to keep the documents in the exact order. And I would just say everything I say today I'm deriving just from the filings we did on this. But my recollection from those filings is that one of the central issues about keeping the documents in the same order is that President Trump kept these incredibly highly classified documents in boxes with all different sorts of things of all different sorts of shapes and sizes. Clothing, memorabilia, newspaper clippings, things of that nature. And so while agents, I think, sought or wanted to keep the documents in order as best they could, I think once they saw the order of these boxes, clearly that was going to be an impossible thing to do. And so we set out our views about that in these filings. And again, I'm speaking only from these filings.
What's the upshot of the documents being taken out of order?
My view is there is no upshot in the sense of these documents were, staff members referred to these documents as the, quote, beautiful mind boxes, meaning they were, and this wasn't just one staff member, it was multiple staff members, and they referred to the fact that Donald Trump, these were his boxes, they were exclusively his belongings in them, he had curated them and what was in them. And so in our view, that was not a live issue in the litigation. Once the defense raised it and said, oh, now that you can't say what order they're in, we think that's a big issue, we responded. But I think ultimately in the litigation, given President Trump stated that he believed these were all these were his documents. And so the litigation in this case, in my view, is not going to turn on the location of documents in the boxes, given his position was all of this is mine.
Do you know if he was intending to save those materials for his presidential library?
You mean the classified documents?
The items in the boxes, all of them.
Well, if his defense were that he was intending to take classified documents that he had no authority to take, and he did it intentionally because he wanted to start a presidential library and keep those documents in the locations that we talked about today, that's a crime.
No, but my question was all the items in the boxes, the shirts and the other mementos, were they being saved for a presidential library? To the extent you were able to develop that in the course of your investigation?
You know, I mean, there were newspaper clippings in there. There were, I think, you know, different sorts of things that wouldn't to me seem like the sort of things that would be in a presidential library. To be honest, I've never been to a presidential library, so, but if I were starting one, I don't think that's the sort of things I would put in it.
Okay, but you didn't develop any evidence during the course of your investigation that the materials were intended to be saved for a presidential library?
I don't recall that, and I also want to be careful of not getting outside the parameters of these filings, because I don't think we addressed that issue in the filings we're talking about.
Okay. And during the times relevant that we're discussing, Mar-a-Lago was protected by the Secret Service. Is that correct?
That's correct.
So to the extent an adversary wanted to come in and steal some of these classified documents, they would have had to go through the Secret Service to get them, right?
Well, as we alleged in paragraph 13 of the indictment, the Secret Service provided protection services to Trump and his family after he left office, including at Mar-a-Lago, but it was not responsible for the protection of boxes or their contents, and the indictment states that Trump did not inform the Secret Service he was storing boxes of classified documents at Mar-a-Lago, meaning they didn't know that they were protecting classified documents.
Right. But if Joe Q. Citizen had classified documents from their time serving in government and they brought it home to their basement, and some foreign adversary was aware of that, it would be much easier for a foreign adversary to break into the Joe Q. Public's basement and take those classified documents. If the foreign adversary wanted to go and get those documents out of Mar-a-Lago, it would have been a lot more difficult. I mean, a person can't just walk into Mar-a-Lago and try to abscond with these materials, right?
I would very much like to answer that question, but I cannot answer that question due to the final report.
Okay. Was there an effort by your office, did you consider seeking the removal of Judge Cannon?
Again, I don't think that's in any public filing, and so I cannot address that given the injunction.
Whether, you know, the internal office discussions involve consideration of removing Judge Cannon? I mean, that's not something you can talk about?
I don't think I can talk about things today, again, consistent with our discussion this morning. If it's not in a public filing, I haven't seen the final report in almost a year. I'm not comfortable discussing issues like that solely because of that issue.
Okay.
I'm trying to be as consistent as I can about that.
Okay. The book by the Washington Post reporters that we were referencing earlier reported that you considered, and by you I mean your office, your collectively, the collective you, considered petitioning the removal of Judge Cannon, but the Solicitor General's office recommended against it because, and if you had gone to the Attorney General, that would have had to been reported to, publicly reported to Congress. Is that something you have a recollection of?
Mr. Kessler, sorry, I just, on this point, I just want to make sure that we're in agreement that the Department of Justice has taken an expansive interpretation of Judge Cannon's order in its application to Mr. Smith, and that he's not permitted to disclose non-public information that may be contained in Volume 2 of the Special Counsel's report. And I know you cited this book, but the email that we both received from the Department of Justice this morning said that this prohibition does not apply to information that has been made publicly available through authorized means. And so if something was leaked to some reporters who wrote a book about it, I would not consider that to be made publicly available through authorized means.
Okay. You got a page in there? Noted, and I'll just to give more context to what I asked, it's on page 349 of the book. It states, the final straw for Smith came when Cannon dismissed the documents case, citing as a basis Thomas's concurring opinion, which carried zero legal weight, making the choice a striking departure from judicial standards. Solicitor General Elizabeth, how do you say her? Is it Prelager?
Prelagar, I think.
Prelager? Okay, excuse me. Ultimately approved the appeal of Cannon's ruling, but the former Garland law clerk rejected Smith's plan to seek to have Cannon recused, saying he didn't have enough evidence to try to remove her. Smith could have asked Garland to reconsider his trusted counselor's position, but he did not. If Garland turned him down, it would have to have been reported to Congress. And so I guess the question in light of your counsel's observation is, if you asked the Attorney General for something and he turned you down, wasn't your understanding that it had to be reported to Congress?
So putting aside this whole
Yes.
situation, I believe it states something to that effect in the special counsel regulations.
Okay, and was that something you were concerned with? That you wouldn't want something like that reported to Congress?
That was not a concern of mine.
I believe earlier you indicated you did not have any communications with White House officials. I think that Martin already asked you about whether you spoke with President Biden. You said no. Did you have communications with any White House staff?
I did not.
Okay. Did anyone in your office?
My office interacted with staff in the White House in the following ways. There was one instance where, that I recall, where we sought to interview a career National Security Council staffer, and to make arrangements to do that interview, we had to do it through the White House. With respect to the classification of the documents that we were using in the classified documents case, there were some of those documents the National Security Council had equities in, and as a result, we needed a contact point to speak to, I believe it was to speak to a career person who could be our contact point for that classification review. And so there was interaction between my staff and people, I believe, from the White House counsel's office. I would add that all of my understanding and my direction was that any interactions would be pursuant and consistent to the White House contacts policy. Okay. And I think also in the beginning of my time as special counsel, there was this litigation I referenced previously about executive privilege, and we noticed both the current White House and though I don't know that we had to, we noticed also President Trump on that in terms of whether they would waive executive privilege or not. I think in that instance, I'm not sure of this, but I think in that instance, we requested the DAG's office to ask the White House about that, and so we didn't have direct contact, but I wasn't involved in those contacts, so I'm not sure.
So nobody in your office had communications with White House Chief of Staff Jeff Zients?
Not that I recall.
And nobody had communications with the counsel's office in terms of your strategies for prosecuting these cases?
No.
In conjunction with your final report, a letter was prepared by President Trump's defense counsel, Todd Blanche and John Lauro, and they raise issues concerning their review of the report over the Christmas season. And they indicate that they were placed in a veritable hardship trying to review the report because the special counsel's office required them to come to DC. The special counsel's office wouldn't let them use their laptop. They wouldn't have access to any internet. Can you walk us through your posture on some of those onerous conditions that defense counsel raises?
Sure, and just for clarity, I'm going to confine my remarks to the election side case because whatever letter they sent or didn't send regarding the classified documents case, I don't remember if there was a letter, but I don't want, for the reasons we talked about, talk about that.
I am referencing the letter in the part 1 of the report.
Okay, great. So I do recall that, and I recall being surprised and disappointed about their letter on that point because my recollection is that I'm not going to remember the specific dates, but I remember we gave them a time period and conditions to look at the report, and it was around the Christmas holidays, and they were unhappy with those conditions, and we then changed the conditions to better suit what they wanted, and I think this is in what I'm talking about, if I recollect it correctly, this may be in the letter that we attached to to the final report as well. And I remember them expressing appreciation to us for allowing them to change the schedule. That's my recollection of that. So when they complained about the schedule, I remember being surprised about that.
Okay.
And again, the letter that we wrote, I believe, reflects this, and that letter will be a better recollection of this than my memory
Right.
a year from now.
They indicate in that letter, though, that they were required to delete prior discovery productions, preventing them from reviewing underlying documents referenced in the report.
Well, the deletion of discovery, that was pursuant to the protective order in the case, and so put aside the final report of their review. The protective order that both parties signed, and again, there'll be a record of this, that protective order stated that when the case was concluded, the discovery had to be deleted, and that was an order that both sides signed with the court, so that was as much an obligation on their part to the court as to us, and by this point in time, the case is as to Donald Trump had been dismissed, whatever date that was in November.
Right, but they're reviewing the final report to try to, position their client to, make some rebuttals and that type of thing, which is certainly, I think you would agree, is a fair reason to want to have access to the report, correct?
Yes.
What types of communications did you or your staff have with the January 6th committee?
So when I was appointed as special counsel, I asked at some point whether we had gotten evidence from the special counsel, from the select committee. We had not, and so I directed my staff to get that evidence, get whatever evidence we could from them, and I think it was in December or so that we did, in fact, get evidence from them and get a copy of their final report. And this is this is referenced in the in our final report. There's a paragraph or footnote regarding that.
Okay. Do you know who at the select committee your staff was communicating with? Were you?
I was not.
Okay, so you didn't have any communications with members or staff at the select committee?
I did not, no.
Okay, and who on your staff did?
What I recall is tasking J.P. Cooney to do this. I don't know if he then tasked somebody else or if he did it himself or with somebody else, but that's who I remember speaking to about this.
Okay. The book we've been referring to reports that on January 1, less than 48 hours before Republicans could lock down all the evidence or perhaps delete it entirely, I don't think we would do that. A committee staffer summoned an attorney from Smith's team to Capitol Hill to receive a hard drive containing the committee's work. Is that consistent with your understanding of what happened?
I wouldn't have remembered that level of detail if you hadn't read it, but we asked to get everything they would give us, and we took everything they gave us, and we disclosed to the defense everything we got.
Okay. You disclosed everything you received from the
Yes,
January 6th
the stuff
committee?
we got from the January 6th committee, I directed my staff to disclose it to the defense.
And the book reports that, Cooney drove to the Capitol and at the last minute succeeded in collecting 2 hard drives containing about 200 interview transcripts, less than 24 hours before Republicans began shutting down the committee's website. Is that something you have any recollection of?
That level of specificity, I don't. I can't say that that's not accurate, but I don't recall that level of specificity.
And do you know if the hard drives that you obtained contained video of the interviews the January 6th committee conducted?
As I sit here right now, I don't recall one way or the other. If they were in there, we looked at them and we provided them to the defense, but I don't know one way or the other.
And when it comes to deleting documents, while the Republicans didn't do that, what I can tell you is that the January 6th committee files, when we were able to have access to them, did not include the videos that they recorded. And so the question is, do you know, and I apologize if I'm repeating this, but do you know if the special counsel's office, took possession of the videos of the interviews? Because we didn't get it, they were gone by the time we had access to it.
Yeah, as I sit here now, I don't know. What I recall is give us everything you can, give us any evidence you can, and then we reviewed that evidence and disclosed it to the defense. What it included in terms of that level of specificity, I don't have that recollection right now.
The videos that they used at their, at the public hearings were obviously snippets, and they were, they were cherry picked. I don't really mean that in a pejorative way, but they were selected to make the points they wanted to make. And if there was a defense attorney involved with the proceeding, if there was a active minority involved with that proceeding, we would have had a chance to point out that the videos are selectively edited and didn't have the full context. And you would agree as a prosecutor that if there is a video, you'd want the whole video, not just the snippet.
Yeah, we asked for everything they would give us, so we wanted whatever they were willing to give us.
Okay. Let's mark the next exhibit, which will be number
18 and 19.
These are exhibits relating to
Thank you.
what I referenced during our last hour about President Trump's access to classified information. Was it your understanding that the skiff that was in existence at Mar-a-Lago before President Trump, left office, was it your understanding that there was a possibility they could have recommissioned that skiff?
Can I just take 1 minute to look at this?
Of course.
Yeah. Okay. Thank you for allowing me to look at that.
Sure. So you would agree if an individual, not necessarily President Trump, is being prosecuted for mishandling classified information and is going to trial, you would agree that putative defendant would have, ought to enjoy the ability to discuss the charges in a skiff with his lawyer, correct?
Yes.
Have an ability to review the documents in question in an environment with his lawyer, correct?
In a skiff, yes.
Right. Now, if, in President Trump's case, he had a decommissioned skiff at Mar-a-Lago, correct?
I'm not sure about that. That may be true. I don't recall that, but
Okay.
I'm not, if there's a filing that says that,
Do you have any recollection, did the defense ask that, the skiff be recommissioned or a secure area at Mar-a-Lago be established so that he can have these communications with his lawyer?
what I recall is that there was a skiff at some point at Mar-a-Lago, or a temporary skiff sort of thing. When you say decommissioned, I didn't know that there was anything like a skiff, unless you can show me something otherwise. I don't remember there being a skiff like there that was like there but not being used. I'm not sure. And again, maybe maybe that's my recollection, but our position about this is reflected in this filing, and it's in sum that the government was not aware of any case in which a defendant had been permitted to discuss classified information in a private residence. And this would be exceptional treatment consistent with the law. I'll just add one other thing that might be helpful is we did work with the FBI to make Donald Trump's review of classified information at this SCIF, and I think it was in Miami, more convenient and easier. I do recall having conversations to do that. We did oppose him having classified documents at his home and social club, which is the same place where he was keeping these illegally. So that is accurate.
Right, but if a SCIF was established, I mean, this isn't just any normal person. This is the former president of the United States, now current president of the United States. And, you know, if a SCIF could be recommissioned at the Mar-a-Lago residence, I mean, why would you have an issue with that?
Well, I think you just hit on it. Any normal person. He should have the same rules as everybody else. And he, at this time, was a private citizen. And I'm not aware of any private citizen in a litigation, no matter how important a person they are, no matter how busy they are, being allowed to have a SCIF in their home for their convenience. Again, I think my recollection is we worked to make his review of classified documents at the SCIF, and I think it was in Miami, more convenient, and we did that, but I did not think it was appropriate because I think he should be treated like anybody else.
Okay. Initially, in the documents case, sorry, not the documents case, the DC election case, how quickly did you want to proceed to trial after that case was indicted? What was the time frame, if you remember?
I know we requested a trial date. There's a public record of this. I think the judge had a status conference where we discussed it. We proposed a date. They proposed a date in 2026. The date that the judge chose was not the date that we proposed, but was, I think, 2 months after the date we proposed.
Right.
I'm going to say I'm going to guess 4 months, but there's a record of that.
Right. Yeah, I think the special counsel's office proposed initially trying President Trump in January of 2024. The judge, Judge Chuckin, came back with the Super Tuesday date, which of course raises a whole other set of questions which aren't necessarily directed to you. But do you think in hindsight that, I mean, how many months, was that 4 or 5 months after when did the indictment drop? Was it August?
The indictment was in August.
August 1st of 2023?
Thereabouts. I don't remember the exact date.
Okay. So we're looking at 4 months or 5 months, depending on when it is in January. That's a pretty aggressive timeline, isn't it?
We organized the discovery in a way that we felt that was a fair date.
Do you remember, you know, as you sit here today, how many pages of documents there were for that case?
I don't.
Okay. Does the number 13 million, I mean, if I told you 13 million, would that be something that you would, you know, sounds about right?
Again, I couldn't say.
And how many witnesses, you know, did the defense need to digest? You know, how many possible trial witnesses did the defense need to digest?
I don't think we got to, because the court obviously didn't accept that trial date, so I don't think we got to that question.
And how many hours of video footage?
You mean like footage at the Capitol of the attack on the Capitol?
Just how many hours of video footage, you know, if the defense was going to take that to trial in 4 months, how many hours of footage would they need to digest?
I'm just trying to think if there was any video footage other than the footage of the attack on the Capitol. I can't answer that. I don't
President
recall.
Trump's defense team, you know, indicated that it was like thousands of hours of video. And so to digest thousands of hours of video, to digest 13 million pages of documents, would have put them in a situation to, you know, either A, not review the documents, or B, you know, they're looking at like reviewing 100,000, you know, pages per day. I mean, do you think that's reasonable?
I thought the trial date that we proposed, given the case, given the discovery, was reasonable, yes.
So if the math works out that they had to digest about 100,000 pages a day, you think that's reasonable?
I don't know if that's the math, and I don't know if that's the proper way to measure it, but I do think the date was reasonable.
And while all this was going on, we went into this a little bit before, but you have the DC case going on, you have the Florida case going on, and you know that President Trump is required to be in Manhattan for the the district attorney of New York case, you know, at any point in time, did you stop to, you know, stop to think that maybe I should have given him a little bit more time to deal with all these cases, these competing cases?
Well, we thought through the dates we asked for. We thought they were reasonable. We also deferred to the judges. So when we asked for a date and the judge picked a different date, I don't recall that we objected to that date.
A lot of times, though, the judge just splits the baby, right?
Well, I don't know that that's always the case. Sometimes they pick the date that one party says, sometimes they pick the other, sometimes it's in the middle, so.
I mean, Judge Chutkin certainly picked the date closer to yours than the 2026 date. Getting back to the Robert Jackson, you know, statement that I read this morning, you know, he concludes that a sensitiveness to fair play and sportsmanship is perhaps the best protection against abuse of power, and the citizen's safety lies in the prosecutor who tempers zeal with human kindness, who seeks truth, not victims, who serves the law and not factional purposes, and who approaches his task with humility. Do you think in hindsight that you exhibited the kindness in dealing with President Trump that Robert Jackson evinces here?
I think in our conducting both of these investigations, we did it consistent with the best traditions of the department and the principles that Justice Jackson was talking about there. So yes, I do think in both cases, we adhered to those principles.
And is it also fair to say that you were, in fact, trying to get these cases wrapped up before the election in 2024?
We were trying to move these cases expeditiously. In our briefs, we cited to repeated Supreme Court precedent that states that the interest in a speedy trial, the right to a speedy trial, isn't just the defendant's right, it's the public's right as well. And given the gravity of these crimes and the public interest, it was our duty to move them forward as expeditiously as we thought fair and reasonable.
Okay. So in hindsight, there's nothing about the aggressiveness of your schedule that you would have done differently?
I thought the schedule was appropriate.
I just have a couple other questions. I'll jump around and I'll be done. Hopefully I can do that very quickly. The Florida case, initially you had a grand jury operating in Washington, D.C. How does that work? You're taking evidence in D.C. for a case that you ultimately decided to venue in Florida. Were you able to use the material from the grand jury in D.C. for the case, or did you have to repurpose that? Did you have to recirculate that material through a grand jury in Florida?
Mr. Castro, I'm sorry, I'm a little concerned that questions about the grand jury in D.C. and the Southern District of Florida may implicate both 6E issues and the scope of Judge Cannon's order.
Enough. Can I ask hypothetically then, if you have a case that you're operating a grand jury in the District of Kansas, and you decide to move a case to, the Central District of California, how would you ordinarily? What's the department's posture on that?
In what sense?
So you have a grand jury operating in Kansas, and you collect evidence. Are you allowed to use that evidence if you ultimately decide to venue a case in the Central District of California, collected in Kansas?
Yes.
Okay. And are there any concerns about that?
You're speaking about a hypothetical case, but I think we're kind of speaking about the case in Florida, and so I think whether there would ever be concerns depends on the specific case we're talking about. And again, I don't feel comfortable answering that because of this injunction, but for the injunction, I'd be happy to answer it.
Okay. Mr. Jordan wanted me to point out that there was a discussion earlier, I think it was with Congresswoman Scanlon, talking about the Pennsylvania election. And I think you used the term that, in the normal course of things, the, things that happened in Pennsylvania. Am I jogging your memory with this?
I know we spoke about that. There was another series of questions about this, so I do remember that, yeah.
Okay. And we just wanted to point out for the record that, there was nothing normal about what happened in Pennsylvania during the 2020 election. The state legislature, who ordinarily is responsible for making, the election law, picking the time, place, and manner, and prescribing the blow-by-blows in an election, was, basically usurped by the Pennsylvania Supreme Court. And they changed all sorts of things in the 2020 election. For example, they said that the election, instead of ending on, ordinarily would end on a Tuesday, election day, was going to end on a Friday. The Supreme Court said that where signature verification was ordinarily required, that was the Pennsylvania state legislature's, that's how the statute's set up, in terms of administering elections. And the Supreme Court changed that and said that, signature verification wasn't required. The volume of absentee ballots was completely different than an ordinary election. There were over 2 million, absentee ballots. And so, we just wanted to point out, and I guess ask you the question, were you aware of all these irregularities and disparities because of the, because of the COVID and so forth? So many things had changed by the time it got to election day in Pennsylvania.
What I can say is that some of the issues you raised are the sort of issues that a campaign or someone who's a candidate can raise in the courts, and I believe a lot of these issues were raised in the courts. I think Donald Trump lost those litigations, and as we pointed out in our indictment, that bringing a lawsuit for some of the issues you talked about, that's the proper way to dispute these things, or asking for a recount, as President Trump did in 2 states. Our case was about false allegations of fraud. Our case, the things you just mentioned, we didn't allege those to be